Hearing in the reference by the Attorney General and the Advocate General for Scotland in the UK withdrawal from the European Union Legal Continuity Scotland Bill.
Yes, Joaquin.
Good morning, my lady and my lords. You'll be aware of who's appearing this morning and of the timetable that has been set for this hearing, so I don't intend to address those. I appreciate that we are, in a sense, quite tight for time, and there are a number of preliminary issues which I would just like to raise as we proceed with the reference. And the first point to mention is that on 26 June of this year, the United Kingdom Act received royal assent. And one of the provisions which came into force on that date was paragraph 21(2)(b) of Schedule 3. And the effect of paragraph 1 is to insert the UK Act into the list of protected enactments in paragraph 1(2) of Schedule 4 to the Scotland Act, alongside the Acts of Union and the Human Rights Act, and indeed at present the ECA. And that was the explicit legislative intention when the then UK bill was introduced to Parliament in April 2017. So what effect does that have, and how should that be addressed in the present context? My learned friend, the Lord Advocate's first supplementary case, he now has three. I hope the Lords have received the third.
Number 3 arrived this morning, yes, but it's mercifully short.
Indeed it is, and I'll come on to address it in a moment, if I may. But his first supplementary case accepts that as current law, the change brought about by royal assent to the UK Act can and does have an effect on matters that would otherwise arise on this reference. And indeed, the Lord Advocate in that first supplementary case invites the court to address its effects now. And we agree, with leave of the court. We accept that the change does have an immediate and direct impact on the Scottish Bill, and really neither party is inviting the court to ignore the change in the law made by the UK Act. The only issue between us is the extent of that impact. So, of course, that is a matter for the court to decide, but we would invite the court to proceed on that basis. And indeed, the alternative would, I venture to suggest, be somewhat unattractive, because if the Scotland Bill was to be referred back to the Scottish Parliament, it could be reconsidered. They're not bound to reconsider it. There could then be a further reference to this court in terms of the Scotland Act. Alternatively, there could be an order under Section 35 by the Secretary of State, or alternatively, if the bill received royal assent, then there could be a devolved issue referred back to this court pursuant to Schedule 6, paragraph 34 of the Scotland Act. And beyond that, of course, there could be a valid challenge to the Act resulting in judicial review. And as a consequence of that, the Scotland Bill might, in the form of an Act, find its way back to this court eventually. So if your lordships are with me on that, I would like to proceed in the first instance by simply addressing the impact of the UK Act as it is now in force.
Well, whether or not we're with you on the point in time at which we judge the Scottish bill, it would obviously be convenient for you to start with that substantive issue.
Well, I'm obliged. Now, it's perhaps appropriate to note the approach that the Lord Advocate takes and has taken with regard to this matter. In his original case at paragraph 54, which is at MS 124, and again at paragraph 4 of his second supplementary case, the Lord Advocate asserts a presumption that Parliament is to be assumed not to have changed the law in the course of a pending reference. And I venture that this proposition is untenable, and indeed there is no basis for such a presumption. Parliament legislates as it sees fit in its sovereign position. Its intention is to be ascertained by the words it has used faithfully, interpreted by the courts as they will be. And here Parliament has acted unambiguously. It has specifically set a commencement date for paragraph 21 of Schedule 3, and it has not sought to make any transitional provisions that would affect this reference. There's certainly nothing in the jurisprudence to suggest that there is any presumption of the kind asserted by the Lord Advocate, and that Parliament is to be taken to be aware in any event of this reference. The original case from the Lord Advocate alluded to the Scran Refineries case, but the Article 6 issues that might arise in relation to legislation which affects current proceedings or judgments in private law, where civil rights are at issue, has no application in the present case, and indeed the Lord Advocate himself doesn't suggest otherwise. If there were any constraint of this type, it's difficult to see why it should operate as a presumption only, and why, as the Lord Advocate appears to consider, it would be permissible for Parliament to take direct and explicit action to override the Scottish Bill. But it may be that the Lord Advocate feels that he would be going too far if he was to actually rely upon the essential finding under Article 6. In principle, it's also impossible to see on what basis such a presumption should be made, because the fact of a reference is no basis for legislative restraint by the sovereign parliament. And it's also impossible to identify presumption on the facts, given the inclusion of the UK Act within paragraph 1 of Schedule 4 to the Scotland Act on the face of the UK Bill. And indeed, that's where it was when the UK Bill was introduced to Parliament in April 2017. And indeed, the Lord Advocate's approach would have a surprising consequence. He says that Parliament has legislated in such a way as to deal with the reference. But what would happen if Parliament had legislated on an emergency basis the day after the passage of the Scottish Bill in the same terms as it has, and a reference was made before royal assent? The Lord Advocate's position seems to be that that would be a different case to this, but it's hard to see why, as a matter of principle, it could be or should be. So that's the extent to which I deal with the Lord Advocate's proposition as advanced in his original case and second supplementary case. And I turn then to his third supplementary case, which your lordships received this morning. I received it last night. And again, I submit that the proposition advanced there is untenable. First of all, I do not accept the interpretation of the Government of Wales Act 2006, upon which the proposition is premised, and in particular the interpretation of Section 109 of the Government of Wales Act 2006. Reference is made there to Section 109, subsection 5. I would just notice that the Government of Wales Act, like the Scotland Act, draws a very clear and well-defined distinction between an act and a bill. And the purpose of Section 109, just like Section 30 of the Scotland Act, that I'll come to in a moment, is to deal with the situation in which, due to a change in competence, an existing act which is in force could somehow be impugned for lack of competence. And that is essentially what it is about. And indeed, the explanatory notes to Section 109, subsection 5, say that subsection 5 makes it clear that if a change is made to Schedule 7, that's on competence, and thus to the Assembly's power to pass acts, the change is to have no effect upon acts already passed or approved in the case of acts which have been reconsidered and amended by the Assembly. They will remain law. This is subject to any retrospective provision that may be made in the Order in Council. And in due course, I'll arrange for a copy of Section 109 and the explanatory notes to be handed up to the Court. And I apologise that it hasn't been available immediately. Now, just to put this beyond doubt, I emphasise again that the Scotland Act draws a very clear and coherent distinction between an act and a bill. But if there was any question of substance in the Lord Advocate's third supplementary case, it is, in my view, dispelled when one looks at Section 30, subsection 6 of the Scotland Act, which can be found at MS 426, and we might just refer to that for a moment. This is dealing with essentially the same area as Section 109 of the Government of Wales Act, the situation in which a change of competence may inadvertently have intruded upon an existing act of the devolved assembly or devolved government. And just going to subsection 6, it proceeds as follows. Where the effect of the alteration is that a provision of an act of the Scottish Parliament, and it emphasises act, ceases to be within the legislative competence of the Parliament, the provision does not for that reason cease to have effect unless an enactment provides otherwise. Now, an enactment cannot competently provide that a bill shall cease to have effect because it has no effect. Perfectly clear from subsection 6 that this proposition cannot stand and that the third supplementary case for the Lord Advocate is unsound. Now, I turn then to what is the effect of paragraph 21 of the UK Act and its incorporation into Schedule 4 of the Scotland Act. And what I wish to do, given time constraints, is focus on our primary position, which is that the Scotland Bill as a whole cannot stand in these circumstances. We do have an alternative line of comparison of the provisions line by line, as it were, in our supplementary case and Appendix C of the supplementary case, and I would simply invite the court to consider that in its terms, but I don't think it would be appropriate for me to take up extensive time with that part of the case at this stage. Now, my lords, my submission is that the entirety of the Scottish Bill impermissibly modifies the UK Act and is accordingly outside competence pursuant to Section 29, subsection 2C of the Scotland Act. That's at MS 424. And that's because it is in breach of a restriction in Schedule 4, paragraph 1, which is at MS 541. And that, of course, is concerned with protected enactments. And the provision in particular that an act of the Scottish Parliament cannot modify or confer power by subordinate legislation to modify any of the following provisions. And the following provisions now include the UK Act. Now, in looking at that, could I begin by looking at the object and purpose of the UK Act, which is perhaps most conveniently found from the explanatory notes to the UK Bill, which can be found in Volume 10, tab 81, at MS 3839. And if I can go first of all to paragraph 10 at MS 3844. And it provides that the principal purpose of the bill is to provide a functioning statute book on the day the UK leaves the EU. As a general rule, the same rules and laws will apply on the day after exit as on the day before. It will then be for Parliament, and where appropriate, the devolved legislatures to make any future changes. And then at paragraph 42 at MS 3853,
I'm sorry, where do we find?
It's in volume 10, tab 81, my lord, beginning at MS 3839. I apologise, I'm working from the electronic version.
Well, I was too, but it was telling me there was no page 3844.
Can I seek to suggest that there is, my lord?
Yeah.
But,
well, I'm not going to argue with
There
it.
is, Lord.
I have a spare
My Lord's
memory stick.
idiosyncratic
I would assist.
laptop.
Use the paper.
And I found
It's
it.
a sound policy.
I was going to go on to paragraph 42, which just points out that the approach in the bill to preserving EU law is to ensure that all EU laws which are directly applicable in the UK and all laws which have been made in the UK in order to implement our obligations as a member of the EU are converted into domestic law on the day the UK leaves the EU, subject to some limited exceptions. The paragraphs below set out the different aspects of EU law which operate currently in the UK. The commentary on the provisions of the bill set out where changes to this will occur. So the starting point of the UK Act is to preserve, in most respects, the existing corpus of EU laws that applies to the UK, and to do so in the same way across the United Kingdom. But of course, the Act recognises the future legitimacy and need for devolved institutions to diverge, so Parliament is itself legislating for that. But the starting point is that the same regime applies across the entire country. And if I can take your lordships to paragraphs 36 to 41 of the explanatory notes, beginning at MS 3852, under the heading devolution, the current devolution settlements were agreed after the UK became a member of what is now the EU and reflect that context. In areas where powers have been devolved, each of the current settlements specifies that the relevant devolved institution cannot legislate or otherwise act in a way that is incompatible with the EU law. And the bill amends each of the devolution statutes so as to maintain the current parameters of devolved competence as regards retained EU law. This is intended to be a transitional arrangement while decisions are taken on where common policy approaches are or are not needed. It provides that the devolved legislatures or administrations may only modify retained EU law to the extent that they had the competence to do so immediately before exit. This means that devolved institutions will still be able to act after exit as they could prior to exit in relation to retained EU law. For example, where they currently have discretion over how to implement an EU directive, after exit they will have the ability to modify retained EU law in ways that remain consistent with the underlying directive rather than being constrained by their existing implementing legislation. By contrast, for example, devolved legislation which would amend or otherwise be incompatible with retained direct EU legislation, such as EU regulations, would as now remain outside competence. And it goes on, as I say, to deal more fully with the issue of devolved competence, and I invite your lordships to consider that. Now, it does that, as we've explained in the revised Annex C in our supplementary case, primarily through saving the existence of EU-derived domestic legislation, whether by way of Section 2, Section 3, or Section 4 of the Act. And in addition, Section 12 of the UK Act, which is at MS 697, removes the EU law competence restraint in Section 29(2)(d) of the Scotland Act. So that's at MS 697. But of course, what it also does is to replace that with a bar reflecting the inserted Section 30A to the Scotland Act, which has the effect of the Scottish Parliament having no competence to modify retained EU law in a way designated in regulations. And we'll see that Section 30A, subsection 1, an act of the Scottish Parliament cannot modify or confer power by subordinate legislation to modify retained EU law, so far as the modification is of a description specified in regulations made by a Minister of the Crown. Now, Schedule 2, which is at MS 719 and following, puts in place a series of powers and restrictions, and indeed procedural conditions, to the exercise by the devolved institutions of its powers to modify or alter retained EU law. And in particular, paragraphs 3 and 14, paragraph 3 is at MS 721, and paragraph 14 is at MS 730, mean that the Scottish ministers cannot modify law retained under Section 3 or 4 if it would be in breach of regulations made under Section 12, either generally or in implementation of any withdrawal agreement. So that is the essential structure of the UK Act. I apologise if I'm rushing through this, but Your Lordship may wish to pause just to consider Regulations 3 and 14 at MS 721 and 730 in the context of Section 12.
Sorry, can you say that again, MS?
MS 721 and MS 730 are the Regulations 3 and 14 of Schedule 2, which put in place the powers and restrictions and procedural conditions on the devolved institutions.
Have you an electronic page reference to the new Section 30A?
Yes, my lady. Section 30A comes at MS 697, 698, should be MS 698. It's introduced with Section 12 of the UK Act, my lady.
Is the whole of Section 12 now in force?
It is enforced to the extent of the regulatory making provisions.
That's all. Right.
And what was, sorry, your point about paragraph 3 on 721 was what?
Well, essentially, that the Scottish ministers cannot modify law retained under Sections 3 or Sections 4 of the UK Act if it would be in breach of regulations made under Section 12, either generally or in implementation of any withdrawal agreement. So it's essentially saying that the Scottish Parliament cannot depart from the retained EU law as established by the UK Act, except to the extent that they could have done prior to the UK Act, namely with respect to the implementation of a directive where they have some degree of movement or discretion.
Do we have somewhere the commencement order?
I'm sorry, my Lord.
Do we have the commencement order somewhere for that covers Section 12?
I will check that, my Lord. I will check that.
And what's the difference between paragraphs 3 and 14, Schedule 2?
Paragraph 3.1, beginning, no provision may be made by the Scottish ministers acting alone in regulations under this part so far as the provision modifies any retained direct EU legislation. And then if we go on to, allow me a moment, paragraph 14. No provision may be made by the Scottish ministers acting alone in regulations under this part so far as the provision modifies any retained direct EU legislation or anything which is retained EU law by virtue of section.
So what's the difference? There will be one, I'm sure.
Is it simply that one governs Part 1 of the schedule and another governs Part 2 of the schedule?
Would be.
Can I come back to that point?
You may indeed.
I don't have an immediate answer to that point, I must confess. But what I would point out is the force and effect of both paragraph 3 and paragraph 14, whether or not it be repetitious. But I don't
No,
understand.
it won't be
it's
repetitious.
intended
There
to
will be a purpose.
Indeed.
Is this point covered in your case, or
It is touched upon in our case as well.
in which one? Where?
Well, in the supplementary case, my Lord, which is not in the electronic bundle.
paragraph
Hopefully,
19.
my learned friend has pointed out to me that paragraph 3 is dealing with deficiencies that arise from withdrawal, and paragraph 14 is dealing with the implementation of the withdrawal agreement.
Yes, it's as Lord Reid said, it's one's dealing with part 1, the other's dealing with part 2.
Indeed. So just to confirm that that is indeed the position. I apologise for not having that to hand. Now, against that background, my lords, what the Scottish Bill seeks to do is repeal all references to the ECA and EU law in the Scotland Act. And it seeks to do that by virtue of Section 33 of the Scotland Bill, which is at MS 237, and Schedule 1 of the Scotland Bill, which is at MS 240 to 241. And these repeals, it is proposed, are to be made by way of regulations pursuant to Section 36 of the Scotland Bill. But of course, such repeal is also being made by the UK Act. And the question immediately arises, under which legislation is the repeal to occur? And what if one is given effect by regulations before the other? The Scottish Bill, we submit, is fundamentally inconsistent with the purpose and scheme of the UK Act. Instead of a single body of retained EU law subject to the detailed controls set out in the Act, the Scottish Bill would create a parallel body of retained devolved EU law subject to different and indeed lesser controls. And I would observe that the Lord Advocate's second supplementary case, where he touches upon the UK Act, simply does not address this point. And I would observe that whatever the Scottish Parliament may be able to do by way of reenactment, the Scottish Bill is certainly not reenactment. Indeed, it is essentially a frustration of the Sovereign Parliament's creation of a single body of retained law, because the Scottish Bill seeks to create a second body of retained EU law in the form of devolved EU law. And that, with respect, is precisely what the UK Act does not want. Now, it may be, although it's also telling that it's rather unclear, that the Lord Advocate considers that the Scottish Bill would legitimately create a subset of retained EU law which falls within devolved competence. But that itself would be inconsistent with the structure of the UK Act and the way in which it addresses retained EU law in the areas of devolved competence. Because the UK Act has made provision for what is to occur there, and its provision is not remotely similar to the terms of the Scottish Bill. Now, of course, the Lord Advocate says that duplication is not modification. And he cites, and this is at paragraph 4 of his case in a footnote 106 at MS 142, he cites a Canadian case for the proposition, and I quote, "Mere duplication without conflict or contradiction is not sufficient." Well, this court has warned on more than one occasion of the dangers of using authority from other jurisdictions to interpret the sui generis scheme of the Scotland Act, and indeed, most recently, in imperial tobacco. But in any event, in the present context, duplication is not just confusion, it is also conflict and contradiction, because what is referred to by the Lord Advocate as duplication is in fact undermining the purpose and indeed the scheme of the UK Act. So the Lord Advocate goes on in his supplementary case at paragraph 5, subparagraph 3, and I regret, I don't believe it's on the electronic record, but it's the Lord Advocate's supplementary case, paragraph 5, subparagraph 3, to suggest that this is an exercise in restatement within the meaning of paragraph 7.1a of Schedule 4 to the Scotland Act. And that can be found at MS 547. And what paragraph 7 of Schedule 4 provides is that Part 1 of this schedule does not prevent an act of the Scottish Parliament restating the law or restating it with such modifications as are not prevented by that part. It then goes on to deal with spent enactments. The simple point is that the Scottish Bill does not restate the provisions of the UK Act. What it does is to create a separate and novel body of law for which the UK Act does not provide, termed retained devolved EU law. And all of the provisions in the Scotland Bill concern that body of law, not the retained EU law provided for in the UK Act. And with respect to the Lord Advocate's argument, the restatement exception in paragraph 7.1 is essentially to enable the Scottish Parliament to pass consolidation legislation. Now that has no particular purchase on the enactments which are protected in paragraph 1 of Schedule 4, because frankly it's inconceivable that there would be a situation in which the legislation could be consolidated by the Scottish Parliament. But the exception may have considerable importance to paragraph 2 of Schedule 4 and the prohibition on modifying the law in reserved matters, which could cover large areas of Scots law in which consolidation, to be effective, may need to be addressed. So, with respect to the Lord Advocate's further argument on restatement, we do not understand how the Lord Advocate can, on the one hand, rely on the restatement power, and yet, as he goes on in his case, rely upon some provisions of the Scottish Bill not having analogues in the UK Act, because indeed they do not. And consequently, they're actually direct contradictions and modifications of the UK Act. This simply cannot be a restatement. As to modification, we would say that whatever analysis of modification is adopted, the Scotland Bill is most certainly a modification of the UK Act. It's perhaps worth just noting the Lord Advocate's case on modification, first of all, at paragraph 84, MS 141. He states section 126 of the Scotland Act defines modify to include, amend or repeal. In normal drafting practice, the word includes is used to ensure that an expression is treated as covering something which is not, or more usually may not be, within its ordinary meaning. And in this instance, the definition ensures that modify covers repeal as well as amend. This clearly strikes at an express repeal or amendment of the protected enactments and rules of law. But a provision in an Act of the Scottish Parliament may be held to modify a provision in a protected enactment if it has the effect of repealing or amending the protected enactment, even though it does not expressly alter its text. Where there is no express textual amendment or repeal, the issue can be tested by asking whether there is an inconsistency between the provision under consideration and the protected enactment or rule of law. Now, we would say that that is not the full understanding of what is meant by modification, but even if we take the Lord Advocate's position, it does not save the Scotland Bill as a modification of the UK Act. And indeed, and I'll come on to this in a moment, when we consider what is properly meant by modification, that point is put beyond doubt. The devolved legislative powers, of course, do carry with it the consequence that devolved jurisdictions will have contrasting and indeed potentially inconsistent bodies of law dealing with the same area of policy. Everyone acknowledges that. But the purpose of protecting enactments from modification in Schedule 4 of the Scotland Act is to prevent the emergence of dual inconsistent regimes within the fields covered by these protected enactments. By definition, an enactment included in Schedule 4 is one which the Sovereign Parliament wishes to protect and preserve in order to prevent confusion and uncertainty, and to ensure consistent application of that enactment across the United Kingdom, save where it has provided otherwise. And indeed, we endeavour to give an example of that in our supplementary case with regard to the Human Rights Act, which is, of course, also a protected enactment pursuant to Schedule 4, paragraph 1. And I posed the point in this way: is it really the Lord Advocate's case that the Scottish Parliament has competence to pass tomorrow a devolved Human Rights Scotland Act in material of the same form, using the same legal tools and concepts, but applicable only in areas of devolved competence? How could that possibly be consistent with the obvious intent of the Sovereign Parliament in enacting paragraph 1, subparagraph 2F of Schedule 4, that there be a single human rights regime applicable across the entirety of the United Kingdom? Certainly no one has ever suggested that the Scottish Parliament has the competence to do that. And I submit that they would be obviously right in not advancing such a proposition. But again, one looks in vain in the Lord Advocate's second supplementary case for his position on this point. And in respect of this matter, again, no answer is given. Now, whatever modification means, we say it must cover a context in which citizens of Scotland, indeed, to say nothing of the Scottish courts, are unable to work out whether some aspect of EU law has been retained under the UK Act or under the Scottish Bill, and whether the Scottish ministers are able, as a result, to amend that retained EU law or not. Now, such an outcome is not just an implicit modification of the UK Act scheme, because the effect of it is altered by the Scottish Bill. It fundamentally undermines the core purpose of the UK Act. Now, just elaborating for a moment, if I may, on what is meant by modification in this context. The statutory definition at section 126, subsection 1 of the Scotland Act doesn't necessarily take us much further. That's to be found at MS 515. But it's clearly of broad scope. It simply says that it includes amend or repeal. Perhaps the leading authoritative guidance is that of Lord Hope in Imperial Tobacco, which is in Volume 2, Tab 5, at MS 910. And the issue in that case can really be seen from paragraph 26 of the opinion of the court at MS 919. And it was whether sections 1 and 9 of the Tobacco and Primary Medical Services Scotland Act 2010 modified offences already part of Scots criminal law through the creation of a new offence. Now, the answer given by Lord Hope was no, and that can be found at paragraphs 44 and 45 of the judgment at MS 924. He rejected the argument that the creation of new tobacco-related offences was by itself sufficient to operate as a modification of the existing offences, which paragraph 44 continued in force as before. But what is important is the way in which Lord Hope reached his conclusion at paragraph 45, which can be found at MS 924. And if I can just read from that paragraph, it says, I would reject that argument. The purpose of the offences that these sections create, as I've said, is to discourage or eliminate the sale or supply of tobacco products or smoking materials. If this purpose is realised, that will be their effect. That is plain on the case of the vending machines because of the effect of section 9, is that cigarettes will no longer be available to be sold by this means. The criminal law relating to any sales that may be made in a place where these products are available for sale will not be affected by section 1. It does not create any new offence in regard to any such sales, and the existing offences are not modified. It is not a provision of the kind referred to in section 11 of the 1987 Act, as it is not its purpose to secure that the products are sold as safe, that products that are unsafe are not made available for sale, or that appropriate information is provided and inappropriate information is not. I can see no connection between its purpose and effect and the law on reserved matters. So it's not a modification because the reserved legislation created offences controlling sales of tobacco, and the 2010 Act created new offences prohibiting advertising and vending machines. They weren't designed to reduce sales, but did not impinge on the control or sale to someone who wished to purchase. Now, Lord Hope reasons, as I've just noted, that the criminal law relating to sales that may be made in a place where these products are available for sale will not be affected. Those are his words, will not be affected by section 1. And that is a different thing to textual amendment, implicit or explicit. It interprets rightly modification as a broader concept, undermining the functioning and intention of the reserved matter or the protected enactment. If the 2010 Act had purported to operate in the same area, even if it had supposedly left the existing regime intact, then that would have been a modification. Now, that distinction is, in my submission, precisely what the Scottish Bill fails to respect for the reasons which I've already sought to give. As we set out in our supplementary case, the Scottish Bill is plainly and directly inconsistent with the United Kingdom Act at the most basic of levels, and its mechanisms directly frustrate the purpose of the UK Act. It creates a category of retained EU law additional to the single cohesive body of retained EU law created by the UK Act across the whole of the United Kingdom. The powers given in and under the Scottish Bill run directly contrary to the competence restrictions set out in section 12 of the United Kingdom Act. The powers in and under the Scottish Bill are inconsistent with what is a careful scheme of control, including express restrictions, which are not replicated in the Scottish Bill, set out in respect of the devolved administrations in Schedule 2 of the UK Act. So, in my respectful submission, it is perfectly clear, even upon the Lord Advocate's test of modification, but in any event, upon the correct application of the test of modification, that the Scotland Bill does have the consequence of modifying the provisions of the UK Act. Now, at various points in time, the Lord Advocate has suggested, well, it might have been appropriate to deal with the matter by way of repeal of the Scotland Bill. But with respect, that cannot be right. You cannot repeal a bill. It was perfectly sufficient for these purposes that the UK Act should become a protected enactment for the purposes of Schedule 4 of the Scotland Act. And of course, the Scottish Government and the Scottish Parliament was aware all along that that was the intent of the Sovereign Parliament's legislation. As I noted earlier, the provision that the UK Act should be a protected enactment pursuant to Schedule 4 of the Scotland Act was in the draft bill when it was introduced to Parliament in April 2017. And your Lordships will be aware of the acute interest that the Scottish Government and the Scottish Parliament took in the terms of that bill, and indeed the consequent negotiation that went on over a very considerable period with regard to the terms of the bill, and indeed the proposals that were put forward for amendment of the bill in the Commons, but which were rejected, and which were expressly relied upon by the Scottish Government as justifying their introduction of the Scotland Bill as what they referred to as a negotiating tactic, but which failing a provision that they would carry through on their submission that it was a competent provision for the Scottish Parliament to pass. So I'm conscious that I've taken that at some speed because of the other issues that arise in this case, but the conclusion that we arrive at and the submission we make is that upon any reasonable consideration of the UK Act and the Scotland Bill, it is perfectly clear that the Scotland Bill would operate as a modification of the clear scheme, the coherent scheme set out by Parliament in the UK Act. Whether you adopt the correct test of modification or whether you even fall back upon the Lord Advocate's more limited test of modification as set out in his original written case. The two simply cannot stand together. And as I've indicated already, the proposition that the UK Act cannot be read as having any relevance to the Scotland Bill will not stand, whether on the first argument advanced by the Lord Advocate based upon Strand refineries and the incorporation of what he termed a presumption, or upon his attempted consideration of Section 30 of the Scotland Act, 1998, which does not serve the purpose that he seeks to rely upon it for. It does not apply to a bill. The Scotland Act is absolutely clear on this matter in distinguishing between an act and a bill. And as I noted earlier, if there was any penumbra of doubt about that, it is dispelled by the terms of Section 30, subsection 6 of the Scotland Act itself.
Are you able, I'm having a little difficulty trying to pin down exactly what Lord Hope was saying in paragraph 45 about the meaning of modification. Are you able to put it in a sentence, what you say he was saying? He'd earlier dealt in paragraph 44 with modification in the sense of amending or otherwise affecting anything set out in the protected provision. And then in paragraph 45, he's going on to deal with something different. I'm wondering quite what it is.
As I understand what he's saying, my Lord, is that a modification, and he puts it this way, will occur where a provision will be affected. What he said at paragraph 45 was the criminal law relating to sales that may be made in a place where these products are available for sale will not be affected by section 1. And he goes on to say, of course, it does not create any new offence in regard to such sales. Now that, as I indicated, is different to saying that there's some textual amendment, whether implicit or explicit, of the provision itself. And we would submit that it rightly interprets modification as something that undermines the functioning and intention of the reserved matter or the protected enactment.
Well, I suppose in that case, he wasn't concerned with modification of a provision, but modification of the law on a reserved matter, which I think was consumer protection.
Indeed, sir.
And so
So it was a Schedule 5 reservation, not a Schedule 4 protected enactment that he was addressing.
Yes. So in that context, he's asking himself, does the disputed provision modify the law on consumer protection? And one can see that that wouldn't be restricted to doing something that was inconsistent with the existing law. You could simply amend it, which is obviously within the express terms of Section 1.2, the definition of modification.
Indeed, it's Section 126.
Yes. It's perhaps not quite so easy to see how you apply that reasoning to modification of a specific provision.
Well, with respect, my Lord, it appears to us that where the impact of the relevant provision affects the content or affects the application of the protected enactment, then you do have what is effectively modification. And as I say, we gave the example of, for example, the Human Rights Act as a protected enactment. You might not seek to amend or repeal any term of the Human Rights Act, but you might, by way of a Scotland bill, seek to introduce some parallel human rights provisions in Scotland, which impacted upon the UK-wide provision for human rights and thereby modified the protected enactment and undermined the very purpose of it being a protected enactment.
So you're trying to focus on what the law is that flows from the protected provision and then asking whether that law has been altered in some way.
Whether that law has been modified as a consequence of the bill complained of. And what we have here, and the problem that emerges from the Scotland bill, is that we end up with dual regimes pertaining to retained EU law in Scotland. You have a UK Act that has a regime for the whole of the United Kingdom. You then have a distinct regime introduced by the Scotland Bill for Scotland alone, and the two are not, as the Lord Advocate would claim, simply restatements of each other. They are not in that category of case. They are indeed inconsistent provisions, with the result that you don't know where and when the Scottish ministers may apply by way of regulation to amend that law, or the scope which they actually enjoy to amend that law. You've got two dual but inconsistent regimes in respect of retained EU law. And that, we say, is on the face of it a clear modification of the UK Act as a protected enactment in terms of Schedule 1.
Is the extent of the inconsistency the powers which are given to Scottish ministers under the Scottish Act, Scottish Bill, rather?
It is partly that. It is partly the fact that there are provisions of the Scotland Bill which have no analogue in the UK Act. To take one example, my Lord, but there are quite a number, the Scotland Bill incorporates the Charter,
Yes.
where the UK Act does not incorporate the Charter. Another is with regard to the issue of the right to claim Frankovich damages. Another is with respect to the status of the general principles of EU law. I don't claim those to be an exhaustive list, but they are examples of where the Scotland Bill and the UK Act diverge, with the result that there are dual but inconsistent regimes in respect of retained EU law.
And if, for example, the bill provides for a liability analogous to Frankovich liability, this is presumably post-exit in relation to retained EU law, is it?
It would appear to be.
Well, if the bill provides for Scottish ministers to be under a liability analogous to Frankovich liability, but there is no provision in the UK legislation for the UK ministers to be under any such liability, there's no inconsistency, is there?
Well, with respect, the UK Act is even in that sense undermined, because what is intended to be a uniform provision for retained EU law in terms of the UK Act is undermined. But perhaps a more obvious one is the Charter and the implications of Charter rights on the interpretation and application of retained EU law. How is someone to know or discern what their rights and obligations truly are when they have those dual regimes applying both in Scotland by way of the UK Act and by way of the Scotland Bill? So if I can seek to summarize, as I had earlier, we consider that given that the UK Act is a protected enactment for the purposes of Schedule 4, it is quite clear that the Scotland Bill will operate on its terms to modify the UK Act as it applies in Scotland by introducing this dual but inconsistent regime, and consequently it is beyond the competence of the Scottish Parliament. And that deals with the bill as a whole. But as I indicated earlier, we have also made written submissions with regard to particular provisions of the Scotland Bill, which are highlighted as being inconsistent with the UK Act. And I simply seek at this stage to adopt those written submissions without actually going to them at this stage in my oral submission.
Where are they?
They're found in our supplementary case, and in particular the Appendix C to the supplementary case.
Is the way, I mean, I see the way that general principles of EU law and the Charter are retained is by saying that they form part of Scots law after exit date, on and after exit date. And does Frankovich liability operate in a similar way?
That's something I would have to check.
Oh no, in fact, section 9 of the bill says there's no right in Scots law on or after exit date to damages in accordance with the rule in Frankovich.
I think section 8, rather than section 9, my lord.
Yes.
And if my lord has that, he'll also see section 8, subsection 2. Subject to any transitional, transitory or saving provision made by regulations under section 32, subsection 1 does not apply in relation to any right of action accruing before exit date.
Is that different from the UK Act?
My understanding is that it is different to the UK Act, but I'll double check that.
So the UK Act is retrospectively modifying the law as it stood.
It removes the right to Frankovich damages. lady. But I'll come. Can I come back to the?
Yes, but perhaps come back to it. That seems rather odd.
Well, I'll come back to the precise provisions because, as I recollect, it was the subject of amendment while the UK Act was proceeding as a bill.
Yeah.
So I'll come back to the specific provisions, if I may. Don't know if my lord has any further points arising.
No, not at the moment, thank you.
Now, I was going to move on to the questions proper, if I can put it that way, that were submitted in the reference. And there are, of course, 4 questions. But before doing that, can I touch upon 2 related issues? And they do impact upon later submissions. First of all, the matter of responsibility for the implementation of EU law in Scotland. Now, the Lord Advocate characterises the role of Her Majesty's government in implementing EU law in non-reserved areas by referring to what he terms primary or exclusive responsibility lying with the Scottish government. And I just give the reference, paragraph 18 of his case at MS 106 and paragraph 26 of his case at MS 109. And these assertions appear to be based on the Memorandum of Understanding, but with respect, they ignore the essential characteristic of the Memorandum of Understanding, which is a statement of political intent which creates no legal obligations, a point recognised by Lady Justice Arden in the Horvath case, which is actually cited by the Lord Advocate at paragraph 54 of his written case, and which he otherwise seeks to rely upon. And I would just invite your lordships to note the provisions of paragraph 2 of the Memorandum of Understanding. It can be found at MS 3775.
Which bundle is that?
I don't have the bundle number, but someone will check that for me. I'm told it's volume 10, my lord. And it provides that this memorandum is a statement of political intent and should not be interpreted as a binding agreement. It does not create legal obligations between the parties. Nothing in this memorandum should be construed as conflicting with the Belfast Agreement. So as a matter of law, certainly it's clear that the Scottish Government has no primary or exclusive responsibility for implementing EU law obligations. And indeed, that's plain from the provisions of section 57, subsection 1 of the Scotland Act, which can be found at MS 446. And that provides that despite the transfer to the Scottish ministers by virtue of section 53 of functions in relation to observing and implementing obligations under EU law, excuse me, any function of a minister of the Crown in relation to any matter shall continue to be exercisable by him as regards Scotland for the purposes specified in section 2, subsection 2 of the European Communities Act 1972. Now, the ability of ministers of the Crown to implement EU law for Scotland entails not only lawmaking powers as set out there, but also policy-making responsibility where it's considered appropriate to exercise it. And that's not a matter of bare legal theory, let us be clear, because in practice, since devolution, there has been extensive implementation of EU law in non-reserved areas by Her Majesty's government. And indeed, that's demonstrated by the number and range of statutory instruments which footnote or cite section 57.1 as the enabling power. And in the supplementary appendix, which is volume 11, tab 95, at MS 293 in the supplementary numbering, there's a list of 147 SIs which have been made in that regard, and indeed there are more than 20 which have been made since 2015. And I simply make the point that, because the Lord Advocate seeks to develop this, that the Scottish Government's function of implementing EU law is certainly not exclusive, and as a matter of law, neither primary nor exclusive. Now, a second related point is one that was encountered in the Miller case, and that arises from the Lord Advocate's attempt to establish the existence of what he refers to as the Legislative Consent Convention. Now, those who were in the Miller case may recall the Lord Advocate advancing this proposition at that time. And the Legislative Consent Convention, it was said, means that the UK government must seek the consent of the Scottish Parliament to UK legislation which would alter the legislative competence of the Scottish Parliament or the executive competence of the Scottish ministers. And indeed, the Scottish Government goes further and says that it must also secure the amendment of that legislation if the Scottish Government's consent or the Scottish Parliament's consent is not forthcoming, which might seem a somewhat extraordinary proposition, but that's to be found in the Scottish Government's policy memorandum for the Scotland Bill, at paragraphs 13 and 14, which can be found in the supplementary appendix at MS 275 and 276. Can somebody give me that? Because I don't have it electronically. 11 of this supplement. I think, in fact, that may be an erroneous reference. Can I come back to that? It is the Scottish Government's policy memorandum for the Scotland Bill at paragraphs 13 and 14, but I don't think the MS number is as I indicated it, so I'll come back to that reference.
What's the name of the document?
It is the Scottish Government's policy memorandum for the Scotland Bill, my Lord.
Well, seems to be the correct reference as far as I can make out.
I had gone to the supplemental, and I think, in fact,
It's in the main bundle.
It's in the.
It's in the core volume.
It's in
So the MS numbers are from the core volume, yes.
273.
Are you going to come back to the alleged inconsistency arising out of the incorporation of the Charter?
I will come back to that if your Lordship wishes us.
Yes, the policy memorandum was at 273 of the...
Yeah.
Yes.
That is the Scottish Government's policy memorandum for the Scotland Bill.
Yeah.
And you wanted to draw our attention to which paragraphs?
It's paragraphs 13 and 14.
It's page 275.
Which is at MS 275, the foot of 275. And it says, as the UK Act is drafted, with neither the Scottish Government nor the lead committee in the Scottish Parliament able to recommend it for consent, it is necessary to consider options following consent being withheld if the UK Government will not support the changes to the bill which would allow it to be given consent. Then the Scottish Government recognises that the consequence is that it and the Scottish Parliament must take responsibility themselves for preparing devolved law in Scotland for UK withdrawal. To the extent to which consent is withheld to the bill, it will have to be amended so it does not apply to matters within the competence of the Scottish Parliament or change the role of the devolved institutions. And we certainly take issue with that proposition. not least if it's to be incorporated into part of what is now being termed the Legislative Consent Convention. There is no legal basis for that proposition. Now, this isn't just a matter about labels. The Sewell Convention, as the court will be aware, is now reflected in Section 28, subsection 8 of the Scotland Act. And it precisely tracks the language used by Lord Sewell when he first articulated that convention. And of course, it's quoted in the Miller case. I simply give the reference to paragraph 137, MS 1107. But that is the scope of the non-justiciable convention, the matter of legislating with regard to devolved matters. Quite separate from that is the practice, not even a convention, arising under Cabinet Office technical guidance notes, known as devolved guidance notes, which are discussed in Miller at paragraph 140 of the judgment, that's at MS 1108. Which provide that the UK government may seek consent for provisions which alter the legislative competence of the Scottish Parliament or the executive competence of the Scottish ministers. And as has been observed in Miller, those practices are entirely distinct from the Sewell Convention. All that actually links them is the practice of the Scottish government of utilising what they term a legislative consent motion in respect of both the Sewell Convention and the DGN practices. But they don't come together, as the Lord Advocate would maintain and the Scottish government would maintain, to form the Legislative Consent Convention, let alone a convention that, according to the Scottish government, would mean that the UK Act had to be amended where consent was not forthcoming. And I just mention in passing the provision of paragraph 2 of DGN 1, which is the first devolved guidance note. That can be found in the supplementary bundle 11, tab 94, at MS 275. The Lord Advocate doesn't actually quote DGN 1, but he refers to DGN 10 and DGN 15, which form part of the list of technical devolved guidance notes. But looking at DGN 1, paragraph 2, it observes, like all agreements under the Memorandum of Understanding, this note is not a binding agreement or contract and does not give rise to legal obligations. It is intended to guide the work of the UK government in accordance with the principles set down in the Memorandum of Understanding. So very much reflecting what was said in the Memorandum of Understanding itself. Now, having made those preliminary points, can I come on to the first question in the reference itself, which concerns the Scotland Bill as a whole, and paragraph 7 of Schedule 5 to the Scotland Act. And that is, of course, the reservation in the Scotland Act with respect to the reserved matter of international relations and relations with the EU. And our submission is that the entirety of the Scottish Bill does relate to the reserved matter of international relations as set out in paragraph 7, subparagraph 1 of Schedule 5 to the Scotland Act. And that can be found, and I just mentioned this by way of reference, at MS 555. Now, your lordships will be aware of the basic structure of paragraph 7. Paragraph 7.1 refers to the reservation of international relations, including relations with the EU. Paragraph 7, subparagraph 2, then provides that the reservation does not reserve the observing and implementing of international obligations, including under EU law. And I would have 6 submissions to make on this point. First of all, withdrawal from the EU is a matter for the United Kingdom Parliament. And the devolved administrations do not have a parallel legislative competence in relation to withdrawal from the European Union. And those are the words of this court in the case of Miller at paragraph 130, which can be found in Core Volume 2, Tab 8, NS 1105. Now, the Scottish Parliament had no such competence because it was a reserved matter, namely relations with the European Union. Now, of course, the act under consideration in Miller was, of course, not the conduct of negotiations or the giving of the Article 50 notice, but the domestic legislative authorization for giving that notice. So it's quite clear from the decision in Miller that paragraph 7.1 of Schedule 5 of the Scotland Act applied to a domestic legislative step. And it did so because such a step self-evidently relates to the subject matter of relations with the European Union. So that, in short compass, is my first point. Second, and in the same way, legislating for the effects of withdrawal in the manner of the Scottish Bill, and indeed now the UK Act, is intimately and on any view sufficiently connected to the withdrawal as to relate to it. And of course, the words relate to come from section 29, subsection 2, paragraph B of the Scotland Act. And just for reference, that's at MS 424. A provision is outside competence if it relates to a reserved matter. So here is outside competence if it relates to relations with the European Union. And there has, of course, been judicial consideration of the meaning of relates to, and we summarize that in our written case at paragraph 24, citing Christian Institute and the case of Martin against Most. And the principles are authoritatively summarized by the court in Christian Institute at paragraphs 29 to 33 of their judgment, and that's in volume A7 at tab 35. And I wonder if we might go to that just for a moment.
Tab 35?
Tab 35 in volume 7, my lord.
MS?
MS 2826, my lord. And the court observed, this court has had to apply...
So which paragraph are you reading from?
29.
I'm sorry, my lord, it's paragraph 29
Thank you.
towards the top of MS 2826, if your lordship has it. This court has had to apply section 29.2b and 3 of the Scotland Act on a number of occasions, and the approach to be adopted is now well established. In Martin against Most, Lord Walker said that the expression relates to was familiar in this sort of context, indicating more than a loose or consequential connection, and the language of section 29, subsection 3, referring to a provision's purpose and effect, reinforces that. That approach was endorsed by Lord Hope and Imperial Tobacco. Whether a provision relates to a reserved matter in the sense explained by Lord Walker is determined by reference to the purpose of the provision in question. That purpose is to be ascertained having regard to the effect of the provision among other relevant matters. As we said in relation to the similar provisions in the Government of Wales Act, in Attorney General for England and Wales and Counsel General for Wales, as the section requires the purpose of the provision to be examined, it is necessary to look not merely at what can be discerned from an objective consideration of the effect of its terms. Determining the purpose of a provision may not be an easy matter. For example, must a single predominant purpose be identified, or will the provision relate to a reserved matter provided one purpose which can be properly attributed to it justifies that conclusion? That question was considered obiter by Lord Hope in Imperial Tobacco. The legislation in issue imposed restrictions upon the advertising and sale of tobacco products and was challenged as relating to reserved matters, namely consumer protection and product safety. And Lord Hope stated, and they quote, "I do not see this as a case which gives rise to the problem which may need to be dealt with if the provision in question has two or more purposes, one of which relates to a reserved matter. In such a situation, the fact that one of its purposes relates to a reserved matter will mean that the provision is outside competence, unless the purpose can be regarded as consequential and thus of no real significance when regard is had to what the provision overall seeks to achieve."
So did the Christian Institute case turn that obiter observation of Lord Hope in Imperial Tobacco into ratio or not?
Essentially, yes, my lady, in my submission. And in Christian Institute, the court continued, "This approach should not be confused with the pith and substance test developed to resolve problems in a number of federal systems to which the Court of Session referred in the present case. Although in Martin against Most, Lord Hope mentioned cases applying that test as forming part of the background to the scheme applied in the Scotland Act, he went on to point out that the phrase did not appear in the Act and that the rules which had to be applied were those laid down in the Act. In Imperial Tobacco, Lord Hope emphasised the latter point when he said the intention was that it was to be the 1998 Act itself, not to decisions as to how the problem was handled in other jurisdictions, that one should look for guidance. So it is the rules that the 1998 Act lays down that the court must address its attention." And they continue, "So in the present case, the Second Division's finding that the pith and substance of the 2014 Act are child protection does not answer the question whether any of its provisions relate to the subject matter of the DPA and the directive. It is necessary only to add that the question whether a provision of an Act of the Scottish Parliament relates to a reserved matter is different from the question whether such a provision modifies the law on reserved matters. The latter question is addressed by section 29(2)(c) of the Scotland Act and paragraphs 2 and 4. So the phrase used by Lord Walker indicates more than a loose or consequential connection. And as that phrase indicates, Parliament has deliberately chosen a concept, relates to, which is broad as a matter of ordinary language and broad in this particular context. It is certainly broader than, for example, within. By definition, the disputed provision may be outside the four corners of the reserved matter, but it may still relate to it. In other words, it may fall within the penumbra of that concept as created by the provision. So that is the issue of the degree of connection. Now, as to the factors by reference to which that assessment is made, the authorities indicate that reference is made to the purpose of the provision in question, determined, amongst other things, by its effects. And in that context, one may have regard to materials such as the policy memorandum, a source acknowledged by Lord Hope as a relevant source in that context. And that led the court in Imperial Tobacco to the three-question structure set out in that case and repeated in our written case at paragraph 24, subparagraph 7 at MS 51. If your lordships have that. The analysis of the application of the test is to be structured by means of three questions. What is the scope of the subject matter of the relevant matter reserved by Schedule 5? What is the purpose of the provision under challenge? by reference to that purpose, does the provision under challenge relate to the subject matter? Now, it's perhaps useful to see how the court applied those principles to the facts in the Christian Institute case. If we can go back to that for a moment, and that is at MS 2836, beginning at paragraph 63.
What are we to take from the fact that those three questions, questions 2 and 3, are limited to the purpose of the provision under challenge, when actually the Scotland Act requires the question to be answered not only in by having regard to the purpose, but also to the effect of the provision under challenge? Why is effect being left out of those three questions?
Well, it respectfully appears to me that it's underlining the broad approach that's to be taken to the application of that test.
You ascertain the purpose having regard to the effect. So I suppose, I suppose if one unpacks this, it's assuming you've identified the purpose, yes. And in order to have done that, you've considered the effect.
Yes.
You actually begin with the effect and then draw yourself back to identifying the purpose that has that effect.
Well, that would suggest a purely objective view with no subjective element.
And yet Lord Hope in Martin acknowledged that it was appropriate to have regard, for example, to a policy memorandum expressing the subjective intent of the legislation in order to put it into context.
Well, yes, I mean, one frequently has regard to policy documents of that sort in order to at least ascertain what was the anticipated effect. But I have some difficulty reconciling Lord Hope's use of the concept of subjective intention with the language of the Act.
Well, it respectfully appears to me that it does instruct or inform an understanding of what the intended effect was going to be.
Well, I can see that subjectivity may come into it to this rather limited extent, but what matters is not so much the actual effect as the anticipated effect.
Well, I wonder about that, my lord. Objectively, one is looking at the actual effect.
So far as Parliament can be supposed to have anticipated it when it passed the legislation.
But it's not a purely objective test, in my respectful submission.
Well, it's not according to Lord Hope.
Indeed.
Where are we finding Lord Hope looking for a subjective intention?
If I can come back.
He says it's not limited to objective intention, which I suppose means the same thing.
I think if we look at Lord Hope in Martin at paragraph 25.
Ah, right.
If I just give the reference, my lord, MS 3039.
What if the objective effect is at complete odds with the subjective intention?
I'm sorry, my lord.
What if the objective effect is at complete odds with the subjective intention as to the effect?
Then it would appear that the subjective intention has not been achieved and one's looking at the effect as actually achieved.
So one disregards the subjective intention.
No, the subjective intention may guide one as to what the intended purpose and therefore the consequent effect is, but it's not conclusive.
I have a feeling that this issue may have been considered by the Inner House in Imperial, because I think we were concerned about it's a problem which has also been discussed by the Canadian courts about the problem of trying to attribute an intention to a legislature. And I think the view taken was that it was necessarily an objective assessment, because if you asked what the members of a legislature had in mind, you might get many different answers.
Diverse views. And yet, if you have a policy statement with regard to the proposed legislation, it may guide you as to what the intended effect
But
is.
it tells you what the intention of the government was.
Indeed.
Also in Wilson and County Bank, it deals with the same point.
Yes, and yes. I'm being reminded by Lord Sumption that the same point's also addressed in Wilson and First County.
Could I then come for a moment to Christian Institute again, just to see how the court applied these principles in that context? And at paragraphs 63 to 66 of the judgment, beginning at MS 2836. Now, of course, as your lordships will be aware, the context was an act of the Scottish Parliament creating a named person scheme for the overall purpose of improving child safety and well-being, but which implemented a significant data sharing scheme in order to do so. And at paragraph 64, the court concluded that the information sharing elements were consequential on the well-being promotion purpose. But the reasoning at paragraph 65 is perhaps of some importance. There the court observed, and this is at the foot of MS 2836, it is also important to bear in mind the central aim of the provisions in the Scotland Act concerning reserved matters explained in paragraph 28, that matters in which the United Kingdom as a whole has an interest should continue to be the responsibility of the United Kingdom Parliament. As explained at paragraph 44, the DPA deals with matters in which the United Kingdom as a whole has an interest because it implements the directive in accordance with the UK's treaty obligations by establishing standards of protection of individuals' interests in relation to the use of their personal data and methods by which those standards are to be secured and enforced, which are equivalent in effect throughout the United Kingdom. And there is then a qualification because of the terms of the DPA itself. Now, what the court is making clear there, or reiterating, is the point that the purpose of the Schedule 5 reservations is to protect matters in which the United Kingdom as a whole has an interest. And I've just paused to note an obvious difference in that respect between child protection and well-being as a legislative scheme applicable in Scotland, which may be a classic matter of devolved policy, and the retention of the corpus of EU law in the United Kingdom domestically, which we would submit as a classic matter of national policy.
Well, that might depend upon the subject matter of the devolved, subject matter of the retained law, mightn't it?
But if we look, first of all, at the purpose of the UK Act, it is clearly, and in accordance with the wording in 65, a matter in which the United Kingdom as a whole has an interest. And I merely observe that that is a relevant guide to how one should approach the reservations in Schedule 5.
One of the, in paragraph 28 of the judgment, there's a citation from Lord Hope's judgment in Imperial Tobacco, which the other members of the court agreed, where he gave as one of the examples measures designed to ensure that there is a single market within the UK for the free movement of goods and services.
Indeed. Well, I was going to come on to that dicta and look at it in a little more detail, if I may, in a moment, because one is led to that in the context of what is a matter preeminently of UK interest in this context. And there's also a reference, I believe, there to Articles 4 and 6 of the Act of Union of 1707, which also happen to be protected enactments pursuant to Schedule 4 of the Scotland Act for that reason. So, what we see in Christian Institute is an acknowledgement that matters of UK interest, of national interest, should continue to be the responsibility of the UK Parliament, and that one should bear that in mind when approaching the interpretation and application of Schedule 5. And we would submit that the significance of the withdrawal from the EU and the obvious desirability of consistent and coherent UK-wide approaches to that withdrawal is essentially a clear example of what the court is referring to in Christian Institute, and indeed at the opposite end of the spectrum to the facts in the Christian Institute case itself.
I could see the force of this if the UK Act was the result of a negotiation with the EU, but it's not. It's an act which deals with the position which will arise when there are no legal relations with the EU, at least not in the relevant respect, and this has become part of domestic law. I mean, let's assume that the relate to phrase has the large meaning that you ascribe to it. Why do the facts bring one even within that larger meaning?
Because the issue of how we deal with retained EU law upon withdrawal impacts upon the matter of our relations with the EU.
Why?
Because the manner in which and the extent to which we do retain EU law in the United Kingdom may well impact upon our relations with the EU, whether because they demand that we retain EU law in certain areas or because we feel that it's appropriate to retain EU law in certain areas in order that we are aligned with that body. But it clearly touches upon our relations with the EU, even upon departure.
But those considerations are not extraneous to the Act. I mean, the Act, as my Lord has said, is to set out the position when we withdraw. It doesn't have any direct impact on relations with the EU, does it?
Well, I would disagree with that because, for example, if we decided and reached a situation in which England retained EU law in accordance with this Act, and Scotland decided not to retain that body of law, it would place the United Kingdom in a most invidious and difficult position in the context of its relations with the EU, whether it's a member or not. It would not be in a position to engage with the EU over regulations, standards, and other matters which are pertinent to the matter of our relations with the EU. The whole purpose of the UK Act is to ensure that we have a UK-wide retention of EU law as a starting point. It's not an end point.
But I mean, this submission seems to assume that any provision of Scots legislation which may be the subject of negotiations with an external country or international organization, for that reason alone, relates to international relations.
That would go too far because we are looking at this in the context of the withdrawal from the EU, and it's in that context that the matter has to be considered. So that goes much further than my submission. We're concerned with a particular act, which is the withdrawal from the EU. And it is that which dictates the need for a common position throughout the United Kingdom with regard to the body of law referred to as retained EU law.
Well, this might well justify having an act which made specific provision that the law in the whole of the United Kingdom was to be of a particular kind. But your submission is that the entirety of the Act, simply because it broaches this subject, is beyond competence. And that may itself go
the bill,
too far.
rather than the Act, the law's
So
referring
the
to.
bill, you're quite right to rebuke me. But I mean, you are making the submission now that the bill ought not to broach this subject at all, which is a much wider submission than simply saying that the United Kingdom Parliament is entitled to impose on the whole of the United Kingdom a state of law which is consistent with good relations with the EU.
The United Kingdom Parliament is legislating for the purpose of withdrawal, and in doing so is legislating for the entirety of the United Kingdom. The Scottish Government acknowledges that, but the Scottish Government has brought forward a bill which would have the consequence of there being two or dual provisions with regard to retained EU law upon our withdrawal. And that is contrary to what is intended by the UK Act. It conflicts with the UK Act, which is a protected enactment for the purposes of Schedule 4, Paragraph 1 of the Scotland Act, and is therefore beyond the competence of the Scottish Parliament. It says nothing as to what the Scottish Parliament may do in due course within its devolved competence with regard to the entire body of Scots law. That is a separate and distinct issue. Well, one acknowledged, if I may say so, in Miller, and we'll come on to that dicta in a moment, if I may. But it is important to emphasise that the UK Act legislates for the effects of withdrawal from the EU, and the Scotland Bill also purports to do exactly the same thing. It purports to legislate for the effects of withdrawal, but it does so in a manner that is distinct from that of the UK Act. And indeed, the position with regard to the Scotland Bill is expressly stated in the long title and in Section 1, Subsection 1 of the Scottish Bill itself, which is at MS 210, where it says that the Scottish Bill is in connection with the prospective withdrawal of the United Kingdom from the EU. That is in express terms. And indeed, the purpose and effect of the Scottish Bill is confirmed, as if it was necessary, by the explanatory notes to the bill itself.
Can I give a practical example? The UK Act provides that the Charter does not form part of Scots law. In terms, it says it doesn't form part of domestic law, and domestic law is defined as the law of England, Wales, and Scotland, and Northern Ireland. The Scottish Bill provides that the Charter does form part of Scots law. Right? Now, say, obviously, you found on the inconsistency there, but so far as international relations are concerned, if the Scottish provision is upheld by us, and that act is enacted after the UK Act, it will take priority over it, and the result will be that the Charter will apply in Scotland, but not in the rest of the UK. Now, say the EU then is negotiating with the UK over extradition, and it's only willing to extradite its citizens to territories where the Charter is in force. Then Scots law would meet that requirement. The law of the rest of the UK wouldn't. But the international relations, any negotiation that took place, would be entirely a matter for the UK government. So one would have a difference between the two legal systems, or three legal systems, Scotland, England, Wales, Northern Ireland, which had a bearing, at least a potential bearing on international relations, and it would be possible for the UK government to enter into an extradition agreement purely as between Scotland and the rest of the EU, if so minded. But I wouldn't have. It's more difficult to say that the difference between Scots law and English law would itself relate to international relations. It might have implications for if negotiations were to take place as a matter of international relations conducted by the UK government, but it wouldn't in itself relate to those.
Well, in my submission, one's got to approach the term relates to in the manner in which I've already indicated. It has a wide meaning in that context. And to take another example, if, for example, under the Scotland Bill, the Scottish government or the Scottish ministers were to decide on the labelling of foodstuffs, for example, and to bring out very distinct provisions with regard to labelling, which were quite different to those under retained EU laws provided for by the UK Act. And in the context of withdrawal, we were looking at a situation where we wanted to maintain a single internal market and a level playing field in order that we could maintain relations with the EU even though we're not a member. We would find ourselves compromised by the fact that those provisions had been made in one of the jurisdictions within the United Kingdom. And one of the purposes of the UK Act is to prevent that happening. And that is why, upon withdrawal, we preserve this uniform body of retained EU law for the United Kingdom, and then make regulations to see to what extent one should extend devolved competence in these areas once we have that uniform and clear body of law available.
Are you envisaging a situation where the retained EU law post-exit had been modified by ministers north or south of the border so as to bring about a divergence?
Well, under the Scotland Bill, of course, the Scottish ministers would be in a position, under the Scotland Bill, to be in a position to do two things. First of all, veto regulations made by a Minister of the Crown, which were intended to extend to the whole of the United Kingdom in order to maintain the single internal market. And secondly, they might, as Scotland...
That's a separate point, really. That's your challenge to Section 17.
But it impacts upon the bill as a whole. Yes, it is part of the challenge to Section 17, which I'm going to come to in a moment, and it's a very distinct challenge. But nevertheless, it's an example of how having this dual system within Scotland would impact upon our relations with the EU. If it was open to the Scottish ministers to make regulations that immediately diverged from the retained body of EU law that applied in Northern Ireland, Wales and England, that would place the United Kingdom in an extremely difficult position with regard to its relations with the EU.
I mean, your answer to these questions has really involved shifting the focus towards specific provisions, whereas I think that you are submitting that the whole approach adopted by the Scottish Act of legislating on this subject at all is objectionable. And these are actually two completely different submissions. And I think it's quite difficult for you, when taxed on the problems of your larger submission, to suddenly retreat into your smaller ones.
But I'm not retreating into the smaller one. As I said, we've set out in our written case our particular position with regard to individual provisions for this, from the Scotland Bill. But these are examples of why the Scotland Bill as a whole cannot competently create this dual system of retained EU law upon our withdrawal from the EU. And I emphasise withdrawal from the EU because it is that event which marks us out as quite distinct and different to circumstances in which you might see some change in EU law that could then be occupied on the basis of existing devolved competence. And indeed, that was a point made by this court in Miller. If I might just refer for a moment to the observations in Miller, at paragraph 78, that's at MS 1092. Sorry. And let us see, in short, the fact that EU law will no longer be part of UK domestic law if the United Kingdom withdraws from the EU treaties does not mean that Parliament contemplated or intended that ministers could cause the United Kingdom to withdraw from the EU treaties without prior parliamentary approval. So it's in that context. There is a vital difference between changes in domestic law resulting from variations in the content of EU law arising from new EU legislation and changes in domestic law resulting from withdrawal by the United Kingdom from the European Union. The former involve changes in EU law, which are then brought into domestic law through Section 2 of the 1972 Act. The latter involves a unilateral action by the relevant constitutional bodies, which affects a fundamental change in the constitutional arrangements of the United Kingdom. And that is a very important consideration in this context. And if we go on in the same judgment of this court at paragraph 81, accordingly, the main difficulty with the Secretary of State's argument is that it does not answer the objection based on the constitutional implications of withdrawal from the EU. As we have said, withdrawal is fundamentally different from variations in the content of EU law arising from further EU treaties or legislation. A complete withdrawal represents a change which is different not just in degree, but in kind from the abrogation of particular rights, duties, or rules derived from EU law. It will constitute a significant constitutional change as that which occurred when EU law was first incorporated in domestic law by the 1972 Act. So essentially, the constitutional kaleidoscope is being shaken by withdrawal. And it's how withdrawal from that source of law and body of rights and duties is to be determined domestically, which is, we would submit, intimately linked with withdrawal itself.
The point that is being dealt with here is the difference between a proposition of law about what are the sources of our law and a proposition of law about what are particular rights conferred by our law. It's said that that is a difference of kind. But how does that help you in this particular case? The proposition that the sources of law in Scotland may differ in devolved matters from those in England is one that is embodied in the Scotland Act.
How the United Kingdom intends to give effect to EU law after withdrawal is, I submit, of obvious potential relevance to the terms of any withdrawal agreement, any transition agreement, and indeed any future trade agreement. In all these instances, we're concerned with the UK and the UK's potential relationship with EU and EU law. And that is why it's important for the purposes of withdrawal to ensure that there's consistency across the entirety of the United Kingdom. And in my respectful submission, it's not hard to see that as the potential aspect of any negotiations over future agreements with the EU. We have to begin with a UK-wide retention of EU law for the purposes of withdrawal in order that we can engage properly with the EU now and in the future. And so we would submit that it's quite clear that the Scotland Bill as a whole, introducing, as I've said before, a dual jurisdiction over retained EU law, is capable and indeed liable to affect the UK's international relations for the purposes of Schedule 5 to the Scotland Act. We're not suggesting, contrary to what the Lord Advocate asserts at paragraph 65 of his case, that the Scottish Bill is intended to give effect to a withdrawal agreement. What we're saying is that the Scottish Bill relates to international relations for reasons which include that the treatment and status of EU law in the UK after withdrawal is relevant, potentially relevant to any relationship between the UK and the EU going forward.
Would the status of EU law after withdrawal not be a matter relating to observation and implementation of international law?
Well, I'm going to come on to that in a separate point. The answer is no, and indeed even the Lord Advocate doesn't assert that, but I'm going to come on to that point if I may. And indeed, having regard to time, can I move on to my third point? In the hope
Yes, you've not got far down question one, have you?
Well, the third point is simply the scale and nature of the legislative choices that fall to be made as a result of withdrawal, which are truly UK-wide issues, which fall clearly, we would suggest, within the scope of paragraph 7 of Schedule 5. And mention was made earlier of Lord Hope's observations in Imperial Tobacco at paragraph 29, and it is worthwhile going to that. It's in tab 5 in Appendix 2, MS 920. And he observed, as a starting point, there is the underlying purpose of Part 2 of Schedule 5 itself. It will be recalled that paragraph 1 of Part 1 of Schedule 4 to the 1998 Act provides that an Act of the Scottish Parliament cannot modify Article 6 of the Union with Scotland Act 1706 and of the Union with England Act 1707, so far as it relates to freedom of trade. Part 2 of Schedule 5 contains 11 heads and a total of 67 sections, within which there are numerous subsections and paragraphs. Their content ranges from fiscal, economic and monetary policy in Head A to outer space in Head J. Sometimes the subject matter is described in broad terms, sometimes it is identified simply by the name and date of a statute. There is no common characteristic, but there is a common theme. It is that matters in which the United Kingdom as a whole has an interest should continue to be the responsibility of the United Kingdom Parliament at Westminster. They include matters which are affected by its treaty obligations and matters that are designed to ensure that there is a single market within the United Kingdom for the free movement of goods and services. As the purpose of Part 2 of Schedule 5 is to define the limits of the legislative competence of the Scottish Parliament, anything that does not fall within the matters listed there must be taken to be within competence. Now, I just noticed what His Lordship had to say about a common theme, which includes matters which are affected by treaty obligations. And the treatment of EU law and domestic law after withdrawal from the EU is a matter which is affected and will be affected by the UK's treaty obligations. And there is a common theme here. It was repeated by this court in the Christian Institute case at paragraph 28, that's MS 2825, I don't go to it. But matters in which the UK as a whole has an interest should continue to be the responsibility of the UK Parliament at Westminster. So when examining the scope of any reservation in Schedule 5, it is appropriate to construe it by reference to that context of a common theme. And the other point is that the introduction of the Scottish Bill purporting to cover the same field in ways that often exactly or sometimes mirror the UK Act, but in other areas are significantly different, is legislative disharmony. And it's interesting to notice that the Lord Advocate in his original case, and I just mentioned this in passing, paragraph 68, footnote 90, submits that the Scottish Bill adopts what he terms a broadly coherent approach to securing legal continuity when considered alongside the UK Act. Well, I don't accept that as a correct characterization, but in any event, it's hardly sufficient in the circumstances. Broadly coherent approach to securing legal continuity means that there is not a coherent approach to securing legal continuity. And when one comes to the application of those principles in this context, how the UK deals with withdrawal and the corpus of EU law is a topic of national significance, which is inextricably linked, as Miller indicates, to the withdrawal process. We are looking at what is termed a major constitutional change, and the withdrawal, as was observed in Miller, of a source of UK law. And I quote that advisedly from paragraph 60 of the judgment in Miller. And the point being made by Lord Hope in Imperial and by the court in Christian Institute is really framed around one about the internal single market, amongst other things. And when it's put in those terms, one sees that that is consistent with the inclusion of, for example, the freedom of trade provisions in the Acts of Union in Schedule 4 as further protected enactments. And the point is that legislation for the effect of withdrawal is all about the creation and maintenance of a functioning single market within the United Kingdom. And clearly that objective is undermined by any divergence in approaches as between the Scottish legislative solution and the Scotland Bill and the UK Act.
Is your point that the reserved matters, and on the one hand, and the remaining matters which are all devolved, were drawn up in the context of our membership of the EU, with the result that there could be a devolved area such as agriculture or fisheries, where in reality most of the law was made by the EU, with the consequence that although the subject matter was devolved, the EU itself ensured that there was going to be a single market within the UK, whereas post-exit, unless there is a single decision-making body, that situation is jeopardized.
Lost,
is that
essentially, lost. And that is why this is a matter of UK interest and why it is a matter, as indicated in Miller, where the UK Parliament has to legislate. What happens thereafter in the course of time on the basis of the devolved arrangements between Northern Ireland, Wales, Scotland and England is something quite different. As Miller points out, you're shaking the constitutional kaleidoscope essentially, when you're addressing the question of withdrawal and what you do with this great body of EU law, which has been there for 45 years, and which you're bringing back into the United Kingdom. You have to bring it back as a coherent body of law if you are going to maintain, for example, the internal market, which is one of the common themes that is alluded to both in Imperial and in the Christian Institute case. And as much as anything else, it's a matter of scale. Now, can I at that point move on to my fourth submission, which concerns paragraph 7.2, which the Lord raised a moment ago, because the qualification that we find there, or the exception more properly described, does provide strong support for the submission that Parliament intended paragraph 7 of Schedule 5 to cover domestic legislation of the kind in question when we're seeking to regulate aspects of the withdrawal from the European Union. And simply as a matter of interpretation, the scope and reach of something that relates to relations with the EU is clearly going to be informed, as the Noble Lord suggests, by the exception that's provided for. And here the basic point of interpretation is that one can tell something of the breadth of the rule by the terms of the exception to the rule. Now, paragraph 7, subsection 2 is to be found at MS 555. And what it says is that the reservation in paragraph 7 does not include observing and implementing obligations under EU law. And my submission is that this provision was included, and indeed necessarily included, because otherwise, especially having regard to the breadth of the term relate to, those domestic legislative acts would fall within the reservation. That's clearly the intention. To put it another way, 7.2a has had to be included to make clear that 7.1 does not reserve to the UK Parliament legislative competence to implement and observe international obligations. The natural meaning of relations with the EU and of relates to is that they cover how a member state goes about implementing and observing, or indeed not observing, these obligations, because of course a failure to do so may, in the most obvious case, cause a member state to be subject to infraction proceedings.
Even when they're no longer obligations?
Well, not after they cease to be obligations, but of course we're understanding these provisions of the Scotland Act in the context of the ECA and the understanding at the time the Scotland Act was passed that we would continue as a member of the EU. As was pointed out by the court in Miller, it was not anticipated that in the context of such legislation we were going to be withdrawing from the EU. And the legislation has to be approached in that light in order that it's properly understood. But as an exception to the reserved area in paragraph 7, 7.2 plainly does not cover any domestic legislative or executive act of the kind now under consideration. And as I say, there's no suggestion of that in the Lord Advocate's case. He certainly doesn't attempt to advance the proposition that the Scotland Bill is in fact within the scope of the 7.2 exception. And indeed, in my submission, he's right to adopt that position because whether or not EU law permits legislation in preparation for withdrawal by a sovereign member state, which is not the subject of this reference, it cannot be said that the Scottish Bill is seeking to give effect to EU law.
It might be the machinery in due course by which effect was given to agreement. It would be observing and implementing an international obligation arising under another agreement.
That might be at a later stage, but that is not the purpose of the Scotland Bill at this time in the context of withdrawal. 7.2 is a limited exception, which is essentially permitting legislation and executive activity that would otherwise be covered by the principal reservation. And it is inherently limited. And indeed, even where it's applied, for example, in the application of a directive, the UK government will already have been engaged in the promulgation of the relevant directive with regard to its engagement in Europe in any event. So there will have been input already into the matter, which is then the subject of the exception to the reservation for the purposes of paragraph 7.2. Now, the approach that the Lord Advocate actually takes with regard to 7.2 is perhaps interesting. It's at paragraph 63 of his written case, MS 129, where he suggests that paragraph 7.2 should not be taken to imply that if it were not there, implementing or observing would have been characterised as relating to international relations. And indeed, the Counsel General for Wales seeks to make a similar point. But that, with great respect, is simply and boldly inconsistent with the opening wording of paragraph 7.2. It clearly carves particular actions back out of the reservation that is paragraph 7.1. And that is perfectly clear from the way in which it's worded. The Lord Advocate also suggests that it is part of my case to say that paragraph 7.2 is a conferral of competence, but it quite clearly is not. That's not how the statutory scheme works at paragraph 7. 7.1 is a reservation limiting competence of the Scottish Parliament, and 7.2 is clearly an exception which clarifies what the reservation will not cover as a result of the exception. And indeed, I would agree with the wording that the Lord Advocate uses elsewhere in his case at paragraph 63, that paragraph 7.2 of the Scotland Act, Schedule 5, simply serves to clarify and delimit the reserved matter, which it does. And the key point is that the breadth of the reservation in paragraph 7.1 is actually discernible from and informed by the necessity for the inclusion of the exception in paragraph 7.2. It's interesting that the Lord Advocate, in his written case at paragraph 64, and just for reference, that's MS 130, suggests that if implementing EU law is not within paragraph 7.1, then a fortiori, providing for the continuing effect of EU-derived provisions, and there's no longer an obligation to implement EU law, should not be either. But that's, again, to misunderstand the relationship between 7.1 and 7.2 of Schedule 5. 7.2 creates an exception for something which necessarily would otherwise fall within 7.1. If the exception does not apply, and I submit that it clearly doesn't apply to the Scotland Bill, then 7.1 does apply. In an additional point, the Lord Advocate at one point submits that if that's correct, then other heads of Schedule 5 would be unnecessary, and he refers to B3A and C8. I'm not going to go into the detail of that, but again, that is simply wrong. These are simply further exceptions taken back out of 7.2 and taken back into 7.1, and that is a mechanism that is used throughout Schedule 5 with regard to reservations and exceptions to reservations. So there's nothing unique or unusual about the operation of Schedule 5 in that regard. So I hope that addresses the point that my Lord raised with regard to the operation of 7.2. In my submission, the Scotland Bill does not fall within the 7.2 exception and therefore remains within the reservation at 7.1. Now, the fifth submission I would seek to make is that the Scotland Act proceeds on the assumption and basis that the UK would be a member of the EU, and it is difficult to take issue with that in my submission. That was the subject of a finding about the ECA by this court in Miller with regard to the issue that arose there. That's at paragraph 129 of the court's judgment in Miller. It applies equally in the context of the Scotland Act. The Scotland Act's terms make it clear that the ECA would continue to apply. And indeed, in Miller, the assumption that was made at paragraph 128 of the judgment led to, or at least supported the conclusion that Parliament had no right or had not, in effect, already authorised something as significant as withdrawal from the EU, hence the need for further domestic legislation as a consequence of Miller, the need for a new Act of Parliament in order to serve an Article 50 notice. Now, in my submission, in the present context, that assumption leads to a conclusion of a substantially similar kind. Parliament is not to be taken in the Scotland Act to have ceded power to Scotland to legislate, to deal with the consequence of withdrawal and the domestic legislation ensuing. And in my respectful submission, that would be a deeply surprising intention to attribute to Parliament. Indeed, it's hard to see how it could be attributed to Parliament. When the Scotland Act was enacted, legislative decisions were being made by Parliament about the extent of devolution, of course, but the ECA was already in place and had been for many years. And under the ECA and the treaties to which it gave effect, competence had already been transferred in at least some areas to the EU, and the EU had occupied a whole variety of policy fields. And there had in effect been, as is observed in Miller at paragraph 68, a partial transfer of lawmaking powers to the EU lawmaking institutions. And Parliament cannot be presumed to have transferred to the Scottish Parliament in 1998 a competence the UK Parliament no longer enjoyed and could not have exercised in 1998 compatibly with EU law. So when we do come to withdrawal and the return of EU law, that will include those exclusive competence areas and areas of shared competence where the EU had occupied the field. And they go back to the UK Parliament. And that is wholly inconsistent with the basic misconception of the Scotland Bill, which is that the Scottish Parliament has competence to legislate over the entire area of returning EU law, insofar as they perceive it to fall within what were otherwise identified as devolved areas. And in my respectful submission, the Lord Advocate's argument that devolved competence is automatically widened to include all these areas returning from EU law fails to have any regard to the point I sought to make in my second submission here, that the constitutional kaleidoscope is being shaken up significantly by withdrawal, which means that there is a fundamental constitutional change occurring as a result of withdrawal, which requires us to address what Lord Hope and others have referred to as a common theme, and the necessity of maintaining those issues that are common to the United Kingdom, including the internal market. The Lord Advocate, in his case, places great weight on observations at paragraph 130 in the Miller case, and I wonder if I could just go to that. It's at MS 1105. This is where the court observed, it's at the foot of that page, my lords. Accordingly, the devolved legislatures do not have a parallel legislative competence in relation to withdrawal from the European Union. the EU constraints are a means by which the UK Parliament and government make sure that the devolved democratic institutions do not place the United Kingdom in breach of its EU law obligations. The removal of the EU constraints on withdrawal from the EU treaties will alter the competence of the devolved institutions unless new legislative constraints are introduced. In the absence of such new constraints, withdrawal from the EU will enhance the devolved competence. We consider the effect of the alteration of competence in our discussion of the Sewell Convention below. And what the Lord Advocate chooses to ignore from that observation is the reference to the removal of EU constraints, which will also have the competence of devolved institutions unless new legislative constraints are introduced. And that is the very purpose of the UK Act. It is to ensure that we maintain that common field across the UK upon withdrawal.
Do you disagree with the proposition in paragraph 130?
As long as it's understood in its entirety, I don't take issue with it. There may be, in due course, an extension of devolved competence when we withdraw, but in the first instance, for the purposes of withdrawal itself, it is important that we understand the control mechanisms that the UK Parliament is able to exercise in that regard for the purposes of withdrawal. And that is why, as I say, that whole issue falls within the reservation in paragraph 7 of Schedule 5 to the Scotland Act. As the court observed in Miller, it's paragraph 129, the devolution legislation is premised on EU membership, and it doesn't cater for withdrawal from the EU, and it doesn't cater for areas of competence returning from the EU, or indeed how one addresses the loss of that source of law, or the massive body of rights and duties and rules that go with it. And one cannot, I submit, start with the premise that the starting point of legislative competence of the Scottish Parliament encompasses areas governed by the EU and EU law. One has to take all of this in context. Finally, the sixth point I was going to make in this context is that Parliament's view clearly is that it is for the UK Parliament to legislate in this field and for it to take decisions about the devolution aspects of the effects of withdrawal. And of course that is provided for by the UK Act. And the fact that the UK Act is a protected act that cannot be modified by the devolved legislatures has to be noticed. Parliament has intended to legislate precisely to deal with how devolution is to work with respect to returning EU law. And one has to take cognizance of that. It's also, in my submission, not irrelevant to notice the view of the Scottish government with regard to this matter. They considered that the UK Parliament should proceed with legislation in this area. And the position of the Scottish government was that the Scottish bill, and this is said explicitly in the policy memorandum, was being introduced as a negotiating tactic. And the express purpose is to be found on the face of the policy memorandum in paragraph 6 at MS 274. Indeed, as I mentioned earlier, the Scottish government went so far as to make the assertion that unless the UK bill was amended in accordance with the wishes of the Scottish government and Parliament, it could not apply to Scotland. And I gave that reference earlier, and that's part, I suspect, of the legislative consent convention and related matters that the Lord Advocate raises in various parts of his case. But it is quite clear that in this context, the UK Parliament is dealing with a matter of common interest in respect to the UK, and that the Scottish Government recognised that that was its intent. Now, in their response to these points, the Lord Advocate and other interveners suggest that if our approach to paragraph 7.1 of Schedule 5 is right, then the UK Act would not function, because their argument runs that essentially Schedule 2 of the UK Act provides various powers to the devolved legislatures and administrations to modify retained EU law within devolved competence. But they say if we're right about the construction of paragraph 7.1, there's essentially no devolved competence left. Now, that, with respect, considerably overstates the nature of the case that's actually being made here. We are concerned with the issue of withdrawal, with the UK Act creating a deliberate statutory scheme, secondly, that actually addresses devolved competence, and that's in section 12 and schedule 2 of the UK Act, which specifically gives powers to the devolved authorities in respect of retained EU law in particular context. But the whole purpose of the UK Act is to ensure that upon its return, EU law can be dealt with in such a way that the internal market, the common interest of the United Kingdom, is maintained. So, my lords, that is the 6 points that I wish to make in support of the first question in the reference. Can I turn, albeit briefly, to the second question in the reference, which is section 17 of the Scotland Bill, which my Lord Reid mentioned earlier. And it may be important to single out section 17 for a number of reasons. But one is this, that while I address the Scotland Bill as a whole, it is arguable that because the UK Act has now come into force by virtue of royal assent and is a ring-fence provision in terms of Schedule 4 of the Scotland Act, Section 17 of the Scotland Bill could no longer apply to it. Because it could not be utilised to modify that Act, albeit it could be utilised to modify consequential enactments such as those which are contemplated with regard to trade and customs and other matters. But there is a reason why, in a sense, Section 17 might stand out from the other provisions of the Scotland Bill because of the coming into force of the UK Act itself. But my submission is that Section 17 is in any event outside legislative competence for three principal reasons. First of all, it relates to the reserved matter of the Parliament of the United Kingdom, and that is contrary to Section 29, subsection 2b of the Scotland Act. Secondly, it modifies Section 28, subsection 7 of the Scotland Act, which is a protected enactment under Schedule 4, paragraph 4.1, and that's contrary to Section 29, subsection 2c of the Scotland Act. And thirdly, because it modifies Section 63, subsection 1 of the Scotland Act, which is a protected enactment under Schedule 4, and so that again is contrary to Section 29, subsection 2 of the Scotland Act. But to be clear about one point arising from our written case, I don't insist on the argument at paragraph 52 of our written case that Section 17 modifies the law on reserved matters. So it is on those three matters that I've just outlined that I will submit that Section 17 is in any event outside the legislative competence of the Scottish Parliament. And I wonder if I could elaborate upon that after the luncheon adjournment, and I hope to do that relatively shortly, and in the time remaining go on to deal quite shortly with the remaining two questions in the reference.
You have 5 minutes left before the short adjournment.
Well, I'm quite happy to take it up, yes.
Make use of them.
I'm more than pleased to do so. Fundamental to the arguments that I will advance with regard to Section 17 are the following propositions. First of all, what Section 17 does is restrict the power of the sovereign parliament to legislate for Scotland. And it does so by setting preconditions to its exercise of the power to legislate. Secondly, if those preconditions are not fulfilled, then legislation which Parliament intends to apply to the whole of the United Kingdom will, according to Section 17, be deprived of legal effect in Scotland. And it is notable that the key precondition, consent of the Scottish Government, is not within the Sovereign Parliament's power to secure. Now, although the Sovereign Parliament may choose to disapply the Section 17 requirement for consent in relation to a specific power that it confers, even requiring the Sovereign Parliament to consider in a particular case whether to do so is itself a restriction on its powers. And such restrictions are fundamentally inconsistent with the legislative power of a sovereign parliament. Those points colour each of the three reasons that I will seek to advance on competence with regard to Section 17. And the first of those is it a matter reserved by reason of the reservation of the matter of Parliament of the United Kingdom in terms of the Scotland Act. Now, the reserved matter in paragraph 1C of Schedule 5 is Parliament of the United Kingdom. And of course, we look at that in the context of that term I've referred to frequently before, relates to. In other words, that there should be more than a loose or consequential connection with the Parliament of the United Kingdom. The notes on clauses to the Scotland Bill, as it was, now the Scotland Act, indicate that that reserved matter has a broad scope, and it encompasses all the Parliament's powers, memberships, and privileges. And just as a matter of reference, those notes can be found in the supplementary Appendix 11 at MS 126. And of course, as this court found in Imperial Tobacco, those pre-enactment notes on clauses are a permissible aid to the construction of Schedule 5 of the Scotland Act. Now, we would submit that the purpose of Section 17 is to make the exercise by a Minister of the Crown of a power conferred by Parliament in legislation enacted after the Scotland Bill, subject to a veto by the Scottish ministers, a veto which the Sovereign Parliament itself has omitted or refused to grant. And indeed, it may be observed that this was one of the amendments that the Scottish Government was proposing when the UK Bill was in the House of Commons and which was not accepted. Now, by reference to that purpose, it is clear that Section 17 does relate to the reserved matter of Parliament insofar as it constrains the Sovereign Parliament's legislative power by imposing restrictions on how it's able to exercise that power. And that, in my submission, sums up the fundamental competency issue that arises with regard to Section 17.
Is that a convenient
I'm
moment?
going to come on to the second and third.
Yes, I
points,
thought you'd reached the end of point
and
one.
so that may be a convenient moment.
Good. Well, we'll look forward to hearing from you again at 2:00. The court will now adjourn.